So in December of 2019, the High Court of Australia prohibited common fund orders at the start of securities class actions. So Mike, why is this decision significant?
The significance of the decision will depend on whether fewer securities class actions get filed on an open or opt-out basis. If so, and we return to a system of closed or opt-in classes, it will profoundly change the recovery landscape for the worse. There will be fewer cases, more participation burdens on investors, less involvement by them, fewer settlements, and less corporate accountability. But as we'll discuss today, right now the decision's impact is uncertain and depends in large part on how the various actors, and particularly the plaintiffs' lawyers, respond with regard to filing open classes going forward. It also depends on whether we see changes in the law to restore common fund orders or something comparable, or changes that permit lawyers to charge contingency fees. Either of these would keep us firmly in the open class environment. So in short, it's too early to fully judge the long-term impact of the decision on investors.
Okay. Before being prohibited, how did common fund orders impact things?
Common fund orders were first allowed in 2016. It's not understating things to say that these orders profoundly changed the recovery landscape. More cases got filed, increased competition among funders, lowered commission rates, participation got easier for investors, and there were more and bigger settlements. To understand why, we need to understand their role in the process. In class actions, a representative investor sues on behalf of others covered by a class definition. That definition can be open, meaning it covers all the other investors who bought shares during the class period and have not excluded themselves, or closed, meaning it only covers those investors who opt into the class by signing registration agreements with the lawyers and funders organizing the case. Until 2016, most cases were filed on a closed or opt-in basis. Common fund orders changed that, permitting them to be filed on an open or opt-in basis. Funders bankroll these class action litigations, and Australian lawyers cannot work on contingency. Yet, that may change, which we'll discuss later, but funders can finance class litigation on contingency. The funders pay the legal fees and case costs. If the case succeeds, they get reimbursement plus a percentage of the recovery. Funders make their investment decisions requiring a minimum dollar return to risk their capital, so they set minimum loss thresholds for their funding obligation. Total claims must exceed that minimum for them to make the investment. And if they're confident in meeting it, the case proceeds, and if not, the recovery effort fails. Book building, as it's called, is the process whereby the case organizers register investors with sufficient losses to meet the threshold. Registration agreements essentially boil down to locking in the funder commissions with class members. In Australia, non-representative class members have no responsibility for case costs. By statute, they have no risk of adverse cost awards, the risk that if the class action fails, they'll have to pay the other side's legal fees and expenses. Responsibility for both of those things, case costs and adverse costs, rests exclusively with the representative plaintiff. So everything else in the registration agreements you're asked to sign really doesn't matter to the class members. Common fund orders eliminated the need for this book building process. Instead, cases could be filed open, and with a common fund order, the court essentially picked one of the fee arrangements offered by the competing funders. The court would sometimes modify it, usually to reduce the fee rate further, but would then order its terms applied to all class members. So orders were entered at the start of the cases, so the funder's investment was secured. If successful, each class member paid the same percentage commission rate from their share of the recovery, and this put all class members in the same economic position, preventing those not registering early from free riding on the class action efforts. And here's the key. All class members paid the funder. Please remember that when we discuss equalization orders later as one of several current potential workarounds.
So what were the benefits of common fund orders, Mike?
Common fund orders removed the book building barrier and opened up the system for competition. In almost every matter, we saw multiple funders and lawyers vie for case leadership. Courts resolved their competing applications by what are called carriage motions, essentially beauty contests. Court decisions often came down to picking the qualified law firm and funder offering the best financial terms for class members. As a result, we saw commission rates drop from more than 25% to less than 10% in some cases. In short, common fund orders resulted in cases getting filed more quickly. They weren't slowed down by the book builds. Commission rates dropped due to the competition and further court pressure. Registrations were only solicited for carriage motions. Organizers would argue that backing by institutional investors made them a better choice than their competitor.
And what changed in December?
So in December of last year, in the Brewster and Westpac class actions, the High Court of Australia threw a monkey wrench in the works by prohibiting these common fund orders at the start of cases. And at first it was hoped that they could still be ordered at the settlement stage under a different provision of the procedural rules. But so far the cases have been split. In the Vocus class action, which recovered $35 million, the judge used his discretion to reject a common fund order in favor of an equalization order, which we'll talk about soon. 2 days later, in a non-securities class action involving RMBL, which recovered $3 million, another judge granted a common fund order. And yet a third judge recently concluded he did not have any discretion and denied it. So right now, whether judges have discretion to order common fund orders at the settlement stage varies by judge and will vary by case, which really doesn't help the funders in their initial planning. With front-end common fund orders dead and settlement common fund orders uncertain, at least for now, funders may have to go back to locking in their compensation by contracts with individual class members before cases get filed. This is going to reduce the number of matters filed. That's why we hear a lot of hand-wringing going on right now about returning to a closed class system. But as we'll discuss, that's not necessarily the result if other alternatives emerge that economically permit a continuation of open classes.